Hi, I'm Emily, and I am here with Maya Murphy's attorney, Eva Marie Franco Fox. Attorney Fox practices at Maya Murphy's office in Westport, Connecticut, and is admitted to practice law in both Connecticut and New York. My question today for Attorney Fox is, can a Connecticut prenuptial or postnuptial agreement address the payment of legal fees in the event of a divorce?
That's a good question, Emily. Generally in Connecticut, parties to a divorce pay their own legal fees. Now, certainly the court can order otherwise, or the parties can mutually agree otherwise, and they can make that agreement at the time of dissolution, or they can make that agreement well in advance of a dissolution case, meaning in a prenuptial agreement or postnuptial agreement. Now, if your agreement is going to speak to the payment of legal fees, yes, it certainly can. And if it's going to, it can do so in a number of ways. It can comply with the general standards under Connecticut law that both parties will pay their own fees. It can also dictate that one party will pay some or all of the fees of the other side, or it can even specify that jointly owned assets will be used to pay both sides legal fees. So it really depends. Now, if your agreement is silent on the issue or otherwise defers the issue uh, to a determination made by the court at the time of dissolution, this can play out in a number of different ways. The court can impose its general principle that both parties are going to pay their own legal fees, but the court can also order one party to pay some or all of the fees of the other party the same way an agreement can. And a court may do so if one of the parties is more solvent than the other. So, for example, perhaps they're getting more assets out of the marriage at the time of dissolution and they're in a better position to pay the fees. The court can also do so as a way to sanction one of the parties. So perhaps one of the parties has filed a number of frivolous motions and it's caused the other side to incur fees unnecessarily. They were forced to come to court or to respond to frivolous filings. The court may say, this person wouldn't have incurred so much in legal fees if not for your frivolous motions, and therefore we're going to sanction or penalize you by forcing you to pay some or all of their fees. The court can also use it as a sanction if one of the parties has violated court orders or has been found in contempt of court. The court could say, the other side wouldn't have incurred legal fees if you had simply just complied with your obligations or complied with the court orders, and therefore you're responsible for some or all of their legal fees. Now, the court can also order the parties pay using joint assets. It really depends. And so the parties can address it, as I said, within the agreement, or they can leave it for the court to decide. It's important to know that if you are going to leave it for the court to decide or otherwise have your agreement remain silent on the issue, you may be surprised at what the outcome is at the time of dissolution. It may not be what you intended or what you expected. So generally the best practice is to include language in the agreement that would speak to the issue. Now, obviously, as I said, there are a number of things that could happen that may make a provision such as each party paying their own fees seem unfair at the time of dissolution. So, for example, one party is found in contempt or one party is filing frivolous motions. Your agreement can specify, yes, both sides are going to pay their own fees, except for if one party is in contempt or one party is determined to engage in certain conduct. So it's important to consult with an attorney and make sure that your agreement is drafted appropriately so it contemplates these different issues that can arise within the course of a dissolution action so that everyone is treated fairly and justly within the agreement at the time of dissolution.
Great, thank you so much.